On the 4th of December, I held a press conference where I announced a cap had been put in place under Section 85 of the Act in relation to the subclass 866 visas for onshore protection visas. Now, I said at the time that had taken in also those who had arrived lawfully in Australia and made protection claims, and that I'd be making further announcements about that, and that is what I am doing today and had planned to do today. What the government has now done is that we have put in place, and this decision was taken on December 5 when I approved a further regulation change to restrict eligibility for the subclass 866 protection visa to onshore applicants who had entered Australia lawfully. Now, once that regulation was in place, the cap was no longer necessary, and I took action this week to remove that cap. So the situation remains that those who have come to Australia illegally by boat will not be getting a permanent visa from this government. So that arrangement has now been put in place. On December 14, the new regulation came into effect, and on December 19, I lifted the cap. So that was the set of arrangements that we'd decided to embark upon on the 5th of December, and now they've worked their way into practice.
So I just wanted to try and clarify, if the High Court challenge to your ability to impose that bar succeeds...
That's not what the High Court challenge is about. It's not about the 46A bar.
Is it not in two parts? It was to the cap and to the bar, was it not?
No, it's, well, I'm not going to get into a running commentary on a case that's currently before the High Court, but the 46A bar, to my knowledge, is not the matter that's at issue.
At the end of the day, you're confident that whatever happens in the High Court, you will be able to ensure that none of those asylum seekers here already will get permanent.
The Court will consider the matters that are before the Court, and they'll make their decision, and then we'll go from there.
The claim within the document that was produced by these 15 doctors is that some asylum seekers have been cleared for offshore processing when they've only had 5 minutes worth of medical assessment, and that is equally below the bar when it comes to trying to assess them. Is that your understanding?
Well, that's a claim that has been made, which IHMS and the department... That is a claim that has been made by the individual, and that is a claim that... Well, if you let me answer your question, you've asked it, if you give me the courtesy of being able to answer it. As I said, these claims are being reviewed by IHMS and the department to determine their veracity. And once that's been done, they'll make some recommendations in terms of action.
Minister, these are doctors, 15 doctors working on Christmas Island who have conducted these health assessments. They are doctors with Australian qualifications, right to practice here, they're experienced doctors. Do you take seriously their account of medicine as it is practiced on Christmas Island? Do you take it seriously, or are you in fact simply dismissing what they have to say about their experience on Christmas Island?
Well, I don't think anything I've said today, David, could lead you to your last conclusion. I don't think anything I've said could lead you to that conclusion. The claims that have been raised are being assessed by IHMS and my department. And that's what's being done. They're being taken seriously, they're being reviewed, and to the extent that they require a response, then one will be provided, and that's what I would expect to take place.